before we get into some conversation, I want to get to a question or two from one of our attendees. And again, any and all of you, feel free to talk about the questions and share your thoughts on it in the time we have remaining. The first one, Cary, I want to go back into your presentation on this, and I know that it's also been addressed a bit by Rob and John, but what's the major loophole of the typical ABC test that could discourage a state from adopting it? What are your thoughts on that, Cary? And then Rob and John will ask you to chime in.
I think I'm going to, why don't I punt back to John? I think he's probably in the best position to answer that sort of a more legal question.
Well, as a lawyer for quite a number of years, I never want to talk about loophole. I want to talk about ambiguities and differences in application. I think that there's been a great deal of talk at the state legislature and municipal legislature type of level about the ABC test and whether it actually advances anything or not. It's not so much that there's a loophole, but the various categories are pretty susceptible to buttonhole types of organization status, and so that you can take a look at them and say, I fit in here and I don't, and I fit in there. And most of the entities that are seeking regulation in the independent contractor status for whatever reason are looking for, it seems to me, a more fluid kind of test because the facts change from situation to situation. Rob, how do you see it?
It's certainly, I think some of the entities, some of the states where ABC is being pushed, Massachusetts and California, for example, the B prong is the area where most companies are concerned because it's looking at the nature of the company's business and how integral this contract may be part of it. And obviously, it's going to be an argument for both sides to make. Plaintiffs will try to say it's part and parcel, and the defendants will say, well, wait a minute, under that theory, any kind of, depending on how it's argued, they would say that under this type of theory, you can push to say, well, anything's integral to a business. And you have to then take a step back on the defense side and explain, well, no, this part of the business does X, and what these contractors doing are doing a separate task, a Y task, if you will, and demonstrating the differentiations of what roles each the company and the contractors have in the ecosystem of that particular business model. You have to explain that. So the plaintiffs have a simple thing, which is they're working together. So by definition, they will make that argument. The defendant has to sort of separate out who does what and explain those differences is typically what you see. And again, I would agree with Jonathan, it's going to be case by case. You have to look at the underlying facts of each circumstance.